Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey. So I want you to imagine something for a second. Imagine surviving a really brutal car crash.
Man, yeah, that's already a nightmare scenario.
Right. And then you undergo intense physical therapy, and your doctor prescribes medication so you can just, walk and function without being in absolute agony.
Which is completely standard for that kind of trauma.
Exactly. And eventually you proudly return to your factory job.
Yeah.
You're fully medically cleared for duty, and you do your job well for years.
Okay.
And then, out of nowhere, human resources fires you. And they fire you specifically because you followed your doctor's orders.
Wow. I mean, that's a situation that forces a worker into an impossible choice, right?
Completely impossible.
Yeah.
Like, disobey your doctor and suffer physically, or lose your livelihood entirely. And honestly, it happens far more often than people realize. Yeah, when medical realities collide with corporate bureaucracy, it gets messy. Right. And we actually have a fascinating stack of sources in front of us covering exactly this kind of collision.
We do. We're looking at a legal complaint filed by the Equal Employment Opportunity Commission, the EEOC.
Right. It's a large manufacturing company called the Carlstar Group, LLC.
Yep. And alongside that complaint, we also have the subsequent 2026 consent decree that finally settled this massive federal lawsuit.
Which is super revealing.
Oh, incredibly revealing. It really pulls back the curtain on how a major corporation operates. You get to see this rigid blanket human resources policies on one side, and then the highly individualized protections of the Americans with Disabilities Act, or the ADA, on the other.
Right. So our mission today is to understand how that friction can actually result in a massive six-figure legal reckoning.
Yeah.
But, to understand how a manufacturing giant ends up in federal court facing down the U.S. government, we have to kind of look past the corporate policy itself first.
Yeah, we have to look at the human element.
Exactly.
Yeah.
The human element on the factory floor in Clinton, Tennessee. So let's talk about two specific employees operating heavy machinery down there, Harold Simmons and Timothy Patty.
Right. The stories of Simmons and Patty are really the inciting incidents for this entire legal battle. Both of these men shared a very unfortunate medical background.
Yeah, they did.
Both had suffered severe back and neck injuries stemming from car accidents.
The source material actually gets really specific about Timothy Patty's condition. It notes that it was the result of multiple car accidents, and he was dealing with a pretty brutal diagnosis: spondylosis, L5-S1 disc degeneration, facet joint arthritis, and lumbar dislocation.
Oh, wow.
Yeah, and for anyone listening who isn't, an orthopedic surgeon, let's translate that. In plain English, the literal shock absorbers in his lower spine were deteriorating.
Which is incredibly painful.
Right. The joints were inflamed and the bones were basically grinding together. Every step, every bend, every time he tried to sleep or lift an object, it would send shooting pain through his body.
Yeah. It's a condition that severely limits just, basic, fundamental life activities. So to manage that chronic, debilitating pain and, maintain their ability to work, both men were legally prescribed pain management medications, and this included opioids or narcotics.
Right. But the crucial context here is that these prescriptions, they weren't a secret.
No, not at all.
And they weren't newly acquired either. Both Simmons and Patty had worked successfully for Carlstar for years while taking these exact prescribed medications.
They were doing the job. The medication was essentially the tool that allowed them to function.
Exactly. But the friction sparks in early 2020. Carlstar, like countless other manufacturing companies, maintains a strict drug testing and substance abuse policy.
Right, zero tolerance usually.
Yep. And in February of 2020, both men were flagged for drug tests.
Though the circumstances of the tests were actually slightly different, which kind of highlights how wide the net of this policy was cast.
Yeah, for Harold Simmons, they happened on February 18th. It was just a standard random drug screen. The results came back showing what the company classified as, quote, small opiates.
Okay.
Then, just 3 days later on February 21st, Timothy Patty was tested. But his test wasn't random.
No, he suffered a workplace injury.
Right. And it was actually caused by a machine malfunction on the factory floor.
Oh.
So following standard procedure after an injury, he was drug tested and his results returned positive for opioids.
And the timeline immediately following those positive tests is where the administrative response just completely detaches from medical reality.
It really does.
The company didn't just fire them on the spot, right? Both men were actually sent to be examined by the company's own designated medical professionals to evaluate their fitness to work.
Yeah, this wasn't just Patty and Simmons bringing in a scribbled note from their personal family doctor. This was Carlstar's own medical apparatus.
Right.
Simmons undergoes a return-to-work physical with Dr. Matthew Hine on March 11th. And Dr. Hine actually fills out an official fitness for duty evaluation form. And he specifically marks Simmons, quote, fit for duty without recommendations.
Wow.
Yeah. And Simmons is later examined by Ron Flowers, a physician assistant certified, who also issues a report clearing him as fit for duty.
And we see that exact identical pattern play out with Patty, too. Following the machine malfunction injury, Patty is treated by that same physician assistant, Ron Flowers.
Right.
And the very next day, Flowers hands him a functional capacities form stating he can, quote, return to normal work.
Which is wild because Patty actually goes back onto the factory floor, does his job, gets his stitches removed weeks later, and Flowers officially discharges him from care with yet another return to normal work clearance.
Yeah. And just to close the loop on that, Dr. Hine also examines Patty and releases him to work.
So the doctors looked at the medication, they looked at the men, and they said, safe.
Exactly.
Medically speaking, it really should have ended there. They have legally prescribed substances in their system, but they are fully capable of safely operating the machinery.
But of course, that medical consensus wasn't enough for the bureaucracy.
No, this is the part where the story just goes entirely off the rails. The HR manager at the Clinton facility, Darlene Schumacher, steps in and essentially tells both men that their medical clearances from the company's own doctors are meaningless.
Just completely invalidates them.
Right. She points to a company policy regarding what they broadly classified as, quote, high-risk medications, and delivers an ultimatum.
Change your medications or lose your jobs.
Change your meds or lose your jobs. An ultimatum that completely ignores the reality of chronic pain management.
Yeah, Patty even went back to his own personal physician to discuss this HR demand. And his doctor was adamant. He told him he absolutely could not change or stop his medication because it was medically necessary to treat his disabilities.
Yet HR refuses to budge an inch. And by the end of 2020, both Simmons and Patty are officially terminated.
Unbelievable.
I have to admit, I'm genuinely stuck on this detail. It's like getting a speeding ticket while driving the exact speed limit just because you happen to be driving a red sports car.
Yeah, that's a great way to put it.
They were following the rules, they were using legal medications, and they were repeatedly cleared by the company's own medical experts.
Yeah.
So where does the legal or operational authority even come from? For an HR representative who does not have a medical degree, by the way, to look at a doctor's clearance and just say, nope, I know better.
Well, that is the core pathology of a rigid corporate bureaucracy. You're looking at a system that prioritizes administrative uniformity over human reality. HR departments, they frequently implement these zero-tolerance blanket drug policies because they are incredibly easy to administer.
Right.
It removes all the messy human variables. The spreadsheet simply says, positive test for substance X equals termination.
It's an algorithm. It just takes all the critical thinking out of the manager's hand.
Exactly. And that administrative shortcut is precisely where Carlstar ran afoul of federal civil rights law.
Yeah.
When a company is dealing with employees who have recognized disabilities, they are legally forbidden from using administrative shortcuts.
The ADA.
The Americans with Disabilities Act mandates a process called an individualized assessment. By treating a known medical side effect, which is simply the presence of a legally prescribed medication in their bloodstream, as an automatic blanket disqualifier, the HR department completely bypassed the law.
They substituted a paper policy for an individualized medical consensus.
Yes. They sacrificed the workers to protect the rule book.
And because Carlstar dug their heels in and fired Simmons and Patty anyway, the situation rapidly escalated way out of Darlene Schumacher's office.
Oh, yeah.
The EEOC steps in, elevating this from a local HR disagreement to a massive federal lawsuit in the United States District Court.
And, the EEOC is not an agency that files lawsuits lightly.
No, they don't.
When they act, they build a comprehensive trap. They didn't just sue Carlstar for the act of firing two guys. They systematically attacked the company's entire corporate philosophy regarding employee health.
Right. They leveled 3 distinct legal counts. And the narrative of those 3 charges is fascinating when you piece them all together. So their first swing was count 1, unlawful discharge.
This was the most direct attack. The EEOC argued that Carlstar terminated Simmons, Patty, and actually a larger class of other aggrieved individuals specifically because of their lawful use of prescription medications.
Right.
The ADA strictly prohibits firing a qualified individual because they are treating a disability. If the medication is part of the treatment, firing them for the medication is legally indistinguishable from firing them for the disability itself.
Wow. Okay. Then they went after the infrastructure that caused the firing with count 2, discriminatory qualification standard.
And this is where they attack the blanket policy itself.
Right.
The EEOC demonstrated that Carlstar's substance abuse policy functioned as a qualification standard that inherently screened out individuals with disabilities. And under the ADA, if a company utilizes a standard that disproportionately screens out disabled workers, the burden of proof is entirely on the employer to prove that the standard is an absolute business necessity.
Right, and strictly job-related. And finally, they closed the trap with count 3, failure to accommodate.
Which is arguably the most vital piece of the entire ADA framework. The law requires employers to engage in an interactive process.
Right.
If an employee takes a medication that might impact their job, the employer cannot simply default to termination. They are legally obligated to sit down at the table with the employee and figure out if there is a reasonable accommodation that allows the person to continue working safely. By defaulting to their blanket rule, the EEOC alleged Carlstar just completely ignored this mandatory interactive process.
I mean, I follow the legal logic there, but let me play devil's advocate for a second on behalf of anyone listening who might run a business.
Sure.
We're talking about guys operating heavy manufacturing machinery. We know from Patty's actual case file that a machine malfunction caused an injury on the factory floor.
Right.
So if I'm running a factory, shouldn't I be allowed to ban opioids entirely just to ensure basic safety? Isn't an HR manager really just trying to prevent a fatal accident?
Well, that instinct to prioritize safety is the exact defense almost every manufacturing or logistics company attempts to use in these cases.
It makes sense on the surface.
Right. On the surface, the math seems to make common sense. Heavy machinery plus opioids equals a dangerous environment.
Yeah.
But the ADA is built to dismantle that specific kind of generalized assumption.
Okay, so how does the law differentiate between a legitimate safety concern and an illegal assumption?
The ADA absolutely allows an employer to maintain a safe workplace. What it outlaws is using a broad stereotype to determine safety. You cannot decree that opioids always equal danger for every single human body. The law establishes a very high bar called the direct threat standard.
Direct threat.
Right. To legally remove someone from a job for safety reasons, the employer must prove there is an actual, specific, and significant risk of substantial harm. And crucially, that proof must be based on objective medical evidence, not just a manager's generalized fear of a specific class of drugs.
Which brings us right back to why the HR manager overstepping the doctors was the fatal error.
Exactly.
HR had the objective medical evidence right in front of them, the fit-for-duty clearances from Dr. Hine and P.A. Flowers. But they tossed the objective evidence in the trash and relied on their generalized fear of high-risk medications.
And that is the crux of the entire federal violation. A company cannot legally claim a worker poses a direct threat to the factory floor when the trained medical professionals who physically examined that specific worker state clearly that they do not.
Wow. Yeah, the weight of those 3 EEOC charges, it forced a dramatic shift.
It really did.
While Carlstar formally disputed the allegations and maintained they hadn't violated the ADA, they clearly saw the writing on the wall. They decided not to risk a trial and instead entered into a consent decree, effectively settling the lawsuit under the authority of the federal court.
Yeah, Judge Eli Richardson signed off on that decree on April 15th, 2026.
Right.
And the resolution contains 2 massive components that completely restructure the reality for Carlstar's employees. There's the financial penalty, and then there's the equitable relief.
Let's break down the money first. The total financial payout was $300,000. Now, for a major manufacturing group, a listener might be thinking, is $300,000 really a massive legal reckoning?
Right.
Like, that sounds like a rounding error for a big corporation. But when you look at how that money was distributed, it paints a really vivid picture of the human lives disrupted by this policy.
It reveals how wide the damage spread. Harold Simmons and Timothy Patty, the primary individuals in the complaint, they each received $112,500.
And the breakdown of those payments is actually important legally. For Patty, it was $75,000 in back pay, meaning compensation for the actual wages he lost after being illegally fired. And then $37,500 in compensatory damages.
Right, which is entirely different.
Exactly. Compensatory damages, that's money paid for the emotional distress, the humiliation, and the sheer disruption to his life caused by the company's actions.
Yeah.
And for Simmons, his split was $80,000 in back pay and $32,500 in compensatory damages.
But the EEOC investigation dug deeper and found that Simmons and Patty weren't the only ones caught in this administrative net.
No, they identified 3 other aggrieved workers, Sergio Vargas, Terry Wilcox, and Robert Neville. Each of those men received $25,000, split as $10,000 in back pay, and $15,000 in compensatory damages. But going back to that question of whether this was truly a massive reckoning for a huge corporation, the check they had to write wasn't the real punishment.
Not at all. The true cost to the business, and frankly, the massive victory for the workers, is found in the equitable relief.
Right.
In legal terms, equitable relief means the federal judge isn't just making you pay a fine. The judge is legally forcing you to permanently change your behavior and the way you operate your company.
It's essentially a mandatory court-ordered software update for their entire human resources department.
I love that analogy, yeah.
They're being forced to replace that outdated, lazy, if-this-then-that algorithm with a highly nuanced, labor-intensive, human-in-the-loop system.
Yes. The decree explicitly enjoins Carlstar from denying employment opportunities, even in highly safety-sensitive positions, purely based on an employee's lawful use of prescription medication to treat a disability.
If a medical provider has not restricted an employee's ability to work based on their medication, the HR department is now legally forbidden from inventing a restriction on their own.
They can no longer look at a positive drug test and just say, you're out.
Exactly.
They are now legally required to implement that rigorous direct threat assessment we discussed earlier. And the decree doesn't just suggest it. It spells out the exact 4-step analysis HR must perform on an individual basis.
Yes, rather than an assumption, HR must now evaluate current medical evidence against 4 specific criteria.
Okay, what are they?
First, they must evaluate the duration of the risk. Second, the nature and severity of the potential harm. Third, the likelihood that the potential harm will actually occur. And fourth, the imminence of the potential harm.
Man, to understand how labor-intensive this new process is, imagine a scenario on the factory floor. Let's say a forklift driver is prescribed a new medication that causes mild drowsiness, but only for the first hour after taking it.
Okay.
Under the old blanket policy, HR just fires him.
Yeah, gone. Under these new court-ordered rules, they have to do the work. They have to evaluate the duration of risk, which is only 1 hour. They have to engage in the interactive process. Could they simply shift his schedule so he takes the medication an hour before his shift begins?
Yeah.
They have to explore every avenue to accommodate him?
It demands genuine, rigorous analysis.
Yeah.
And they can't just place a worker on extended unpaid leave to avoid the problem either.
Oh, really?
Yeah, the decree mandates that any decision to restrict an employee must be elevated to the highest corporate HR official at the specific plant.
Wow.
And that official must then consult with a designated corporate-level HR professional just to double-check that every possible reasonable accommodation was fully explored and documented. They built in layers of friction to prevent these knee-jerk administrative firings.
And the court wants proof they're actually doing it. The decree demands a minimum of 3 hours of live in-person training every single year for all HR and management employees involved in reviewing medical restrictions.
3 hours annually, specifically focused on the ADA, reasonable accommodations, and the illegality of blanket policies.
They also have to physically post workplace notices in the factory.
Right.
And the decree specifies that this notice must be signed by the Senior Director of Human Resources, Catherine Stinson. It explicitly details the workers' rights, stating plainly that Carlstar will not deny equal employment opportunities to anyone legally using prescription medications. And it even provides direct contact information for reporting discrimination to the EEOC.
When you pull all of these threads together, the core takeaway for anyone navigating the modern workplace is profoundly empowering.
Yeah, it really is.
Your employer is not your doctor.
Nope.
If you are lawfully taking medication to treat a disability and a qualified medical professional has evaluated you and cleared you to work, your employer's rigid administrative policies cannot automatically override your federal civil rights.
Efficiency is not a legal defense against discrimination. You have a fundamental right to an individualized assessment. You have a right to be evaluated as a human being, not just discarded as a problematic test result.
Absolutely. And for any business owners or managers listening, this case is a massive, flashing warning sign.
Oh, for sure.
If your HR department is acting like an unqualified medical review board, deferring to paper policies instead of individualized medical evidence, you are laying the groundwork for a federal lawsuit.
Which brings up a final, incredibly provocative thought to leave you with today.
Okay.
We just spent this time exploring how a rigid, if this, then that human policy caused catastrophic disruption to people's lives and resulted in a federal crackdown. We saw how incredibly difficult and labor-intensive the mandatory ADA 4-step analysis is for a human HR team to execute properly. But as we look at the trajectory of the modern workplace, we're seeing a massive surge in automated HR monitoring. Companies are increasingly relying on artificial intelligence to scan employee health data, track behaviors, and automatically flag what the system deems risky.
Oh, wow. Yeah, they are actively attempting to remove the human element even further from the equation.
Exactly. So the vital question becomes, how will those hyper-fast, rigid algorithms handle the highly nuanced, deeply individualized legal requirements of the ADA?
Right.
If a human HR manager struggled to comprehend the nuance of a doctor's medical clearance, what happens when a piece of black box software automatically flags your prescription data and locks you out of the factory system?
That's terrifying.
Will artificial intelligence simply become the ultimate discriminatory blanket policy? As we hand more control to software, we might just be building a faster machine to make the exact same illegal assumptions. Welcome to another episode of the Employee Survival Guide, produced by employment attorney Mark Carey.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to mcarey@capclaw.com. That's capclaw.com.